Good evening. This side Rahul Magan here, second year law student. First of all, I wish to thank you, Honorable Supreme Court of India, once again. Because once again, Honorable Supreme Court of India came up with a landmark judgment. Well, if we evaluate the history of Supreme Court, then Supreme Court did numerous landmark judgments. Numerous. And when it comes to the FIR, which is the first information report, and when it comes to charge sheet, the list is really very long. And today, there is one more judgment by Honorable Supreme Court of India. We are having one of the finest judgments by Supreme Court, like Lalita Kumari State versus UP. And ladies and gentlemen, you would be surprised to know that if you buy the Bare Act of Supreme Court Rules 2013 from your nearby district or maybe High Court, then you would see that at page number 162 of the Bare Act, you will see the list of the citations which is mentioned, which are basically to be evaluated under AOR, Advocate on Record paper. And one of the item of this citation is Lalita Kumari State versus UP. We all remember Adesh Kumar State versus Bihar. And there are numerous landmark judgments by Honorable Supreme Court. As you understand that my area of interest is definitely EOW, which is Economic Offences Wing, and technically which is PMLA, Prevention of Money Laundering Act, because I myself is a ex, you can say that financial market person. I dealt as a corporate treasurer, handled the front office piece, and more importantly, I know all banks, financial institutions, and I know how exactly things work as compared to what it is mentioned in the books, including the accounting. And second piece of interest is definitely the criminal law. There is hardly any doubt that I'm having a very keen interest in the criminal law. Yes, now I have launched my own short YouTube channel, so I'm posting a minute video on the criminal law since time is definitely a constraint. Coming to the point, this is the copy of the judgment which I downloaded from Live Law. Now I'm having a subscription of the Live Law, so I went there, I downloaded the judgment. This judgment is having 12th March 2024. It means the yesterday's judgment. 12th March 2024, and Lordship Bela Trivedi ma'am and Lordship Pankaj Mittal sir delivered the judgment. This judgment is via a criminal appeal number 1511 of 2024, which is originated out of SLP. SLP stands for Special Leave Petition, which is under 136, Article 136 of the Indian Constitution, which is originated from SLP criminal number 2874 of 2023. The parties are W. Kujur and State of Jharkhand. Right. Now, in this judgment, this is one of the finest judgment, guys, let me tell you, because here Supreme Court give the directive guidelines. Now, in this judgment, if I go to page number N2, what Supreme Court is saying, before parting, it may be noted that on 17th July 2023, this court, Justice Sanjeev Khanna sir and Lordship Bela Trivedi ma'am passed the following orders. Having gone through the charge sheet, we must observe that it is bereft of any details and particulars. The Director General of Police, DGP, State of Jharkhand, will examine whether the said charge sheet is in accordance with the law, and if such charge sheets are being filed, appropriate steps should be taken in compliance with the relevant provisions of the Code of Criminal Procedure, shortly known as CrPC. I told many times that the laws are divided into two parts, which is the procedural law and the substantive law, shortly known as penal laws. Now, procedural law means the steps which to be taken to reach to a relevant penalty. We are having Code of Civil Procedure, we are having CrPC procedural law, Many people believe that Indian Evidence Act 1872 is procedural and also substantive in nature. But technically, my respectful opinion is that Indian Evidence Act 1872 is more or less procedural and very less substantive in nature. Let's see when the new laws are coming effective 1st July 2024, how the things would shape in the fresh Evidence Act which is coming on the table. We are told that the similar charge sheet bereft of details and particulars are being filed in the state of Bihar and Uttar Pradesh. A copy of this order will also sent to the relevant DGPs of so and so states. So you can go to page number 2 of the judgment. It is mentioned. Now, what Supreme Court has mentioned, which is very important, or page number 3, the police report submitted by the police under 173(2). We need to understand that the charge sheet is shortly known as police report. Now, police report, some people are refer this as a final report also. Now, police reports submitted by police under 173(2), being very important piece of document from the point of view of prosecution, the defense, and the court. We deem it necessary to elaborately to deal with the various aspects involved in the said provision, which means 173. For the reasons stated hereinafter, we are of the opinion that it is incumbent on the part of the investigating officer to strictly comply with the requirements of said provisions, as non-compliance thereof gives rise to many legal issues in the court of law. Please take a note that what Supreme Court is saying, page number 3 of the judgment. For the reasons stated hereinafter, we are of the opinion that it is incumbent on the part of the investigating officer to strictly comply with the requirements of said provisions, as non-compliance thereof give rise to the many legal issues in the court of law. More importantly, if you read the paragraph number 8, then Supreme Court linked the 173, section 173 of the CrPC with section 2R. As we all understand that in all acts, whatever act you say, CPC, CrPC, IPC, arbitration, PMLA, insolvency, bankruptcy, securitization, and whatever act you say, there is an interpretation clause. Now, interpretation clause means everything is interpreted like this means this means this means this is what the interpretation is actually is. Remember that the more clarifications are always available in the General Clauses Act also. So in case there is a clarification issue, we can refer the General Clauses Act also. Please take a note. Now, if we refer paragraph number 9 of the said judgment, then Supreme Court explained what is there in section 173, what is mentioned in actually, which is the legislator intent of section 173. 173 is technically divided into 8 parts, which is subsection 1, 2, 3, tick, 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 subsection 8. Having said that, two important subsections, one important subsection to me, I wish to mention, although all are important, and specifically, I would say subsection 6 and subsection 8 is really very, very important. Now, the first, if I go to subsection 2, and in subsection 2, I refer part 1B. Now, here it is saying nature of the information. So what kind of information a relevant police officer or a police station is getting? If we refer D, whether any offense appears to have been committed, and if so, by whom? Now, whether any offense appears to have committed, if so, and by whom? If we read part 2, subsection 2, then it is saying the officer shall also communicate in such manner as may be prescribed by the state government the action taken by him to the person. Remember, action taken by him to the person, if any, by whom the information relating to the commission of offense was first given. So, action taken by him to the person. So, relevant XYZ person who gives the information to the police officer that this cognizable offense happened. Very importantly, if we refer subsection 6, it is clearly saying that if the police officer is of opinion, now please note that the word opinion, cognizance, reasonable belief, there are catena of judgments by Honorable Supreme Court whereby it is extremely ill-adequately defined. So please don't expect from me that I am going to be defining the opinion, reasonable belief, beyond a reasonable doubt. There are enough judgments by Honorable Supreme Court which not only clarified these issues but also linked them with the XYZ judgments. Now, once again, coming to the subsection 6, if the police officer is of opinion that any part of such statement is not relevant to the subject matter of the proceeding, or that its disclosure to the accused is not essential in the interest of justice and is inexpedient in the public interest, he shall, please take note of word shall is used, not may. He shall indicate that part of the statement and append a note requesting the magistrate to exclude that part from the copies to be granted to the accused and stating his reasons for making such request. Now, we all understand that when the charge sheet is filed before the magistrate, the immediate next step is the CrPC 207. Generally, people say you get the FIR copy, you get the charge sheet copy, but technically speaking, I've been to the catena of judgment, and my personal opinion is that there are numerous landmark judgments by Honorable Supreme Court which clarified 207. In short, even 207 is further categorized by a few high courts that some documents on which the state is relying because, this document is in the favor of the state. Some document the state is not relying because these documents are not in the favor of the state. So 207, I repeat, CrPC 207 in itself is one of the research areas, and a lot of judgments are available in that regards by Honorable higher courts and of course the Honorable Supreme Court of India. More importantly, when it comes to CrPC 207, please take a note, when it comes to CrPC 207, we also need to understand that the accused, say XYZ, his defense is outrightly based on the documents which are provided to him. That what are charges against him, on what grounds our charges are framed, whether there is any witness under section 161, whether there is any statement which is made up by XYZ person under section 164, whether there is any notice which is issued under section 91 CrPC, and ladies and gentlemen, the list is very long. Of course, if the time permits, we'll have a detailed video covering CrPC 207 also. Now, please also take a note, which is very important, subsection 8. It is saying nothing in this section shall deem to preclude further investigation in respect to the offense after report under subsection 2 has been forwarded to the magistrate. It means the relevant police authorities can still continue towards the investigation of XYZ cognizable offense even if the charge sheet has been filed. Very simplistic language, it is called supplementary charge sheet, which means that once the main charge sheet or the first charge sheet is filed, police continue to investigate, and if they find yet another evidence or any kind of witness or any kind of testimony or deposition, then they can have a supplementary charge sheet also. Has been forwarded to the magistrate, whereby upon such investigation the officer in charge of the police station obtains further evidence, oral and documentary. He shall forward to the magistrate in a further report all the reports regarding such evidence in the form as may be prescribed. Please take a note that I used a word oral evidence. Technically, I not use the word, it is part of the code. Please take a note that the oral evidence is also ill-adequately defined by Supreme Court of India. Ill-adequately defined by Supreme Court of India. Today, I was reading one of the judgments of Supreme Court, which is titled Nirmal Prem Kumar and another, State Representative by Inspector of Police. Now, this is a criminal appeal, which is the citation is 2024 SCC Online SC 260. 2024 SCC Online SC 260. In this, if you refer to page number, although let it be very honest that I am not sharing the complete of this judgment. Now, in paragraph number 18, Honorable Court, Supreme Court is saying that law is well settled, that generally speaking, law is well settled that generally speaking, oral testimony may be classified into three categories: wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable. There are other judgments also which speaks about how the oral testimony or what is a settled law pertaining to the oral testimony in now if we read page number and 6, it is said that page number and 6, it is said that as per section 169, upon completion of investigation, if it is appears to the officer in charge of the police station, there is not sufficient evidence or the reasonable ground of suspicion to justify the forwarding of accused to the magistrate, such officer, if such person is in custody, released him on executing a bond with or without sureties, as the officer may direct to appear. If so, if and when so required, before the magistrate empowered to take cognizance of the offense of the police report and try the accused or commit him for the trial. Ladies and gentlemen, CrPC 169, which is more or less the closure report, you can say, and section 170 is very important. In section 170, it is said that cases to be sent to magistrate when evidence is sufficient. Now, this is a very important line, when evidence is sufficient. Point number 1, which is subsection 1, if upon an investigation under this chapter it appears to the officer in charge of the police station that there is insufficient evidence or reasonable ground. Now let me tell you that reasonable ground has already been defined not only in the criminal jurisprudence but also in the EOW, and specifically EOW is the PMLA. Reasonable ground is explicitly defined by Honorable Supreme Court in Prevention of Money Laundering Act, that what is reasonable ground when it comes to Directorate of Enforcement. Right. Similarly, the reasonable ground is explained by Honorable Supreme Court numerous times in the criminal jurisprudence also. Now, it is saying that if upon an investigation under this chapter, it appears to the officer in charge of the police station that there is a sufficient evidence or the reasonable ground as aforesaid, such officers shall forward the accused under the custody to the magistrate empowered to take cognizance of the offense upon a police report and try an accused to commit him for the trial. Ladies and gentlemen, we really need to understand that Honorable Supreme Court already clarified that Section 170 does not mean that you're supposed to take the accused into custody. Right, sections, because in family cases, in matrimonial cases, and there are various cases where CrPC 41A is applicable. Yes, of course, in PMLA 41A is not applicable, but having said that, there are, in the criminal jurisprudence 41A is applicable. So please take a note that section 170 of CrPC to read with section 41A of CrPC, that where 41A, and it is good that if we connect this with our landmark judgment Lalita Kumari State versus UP. And of course, please take a note that when I'm using a word landmark judgment, I mean to say we're supposed to read it thoroughly, not the operative part of it, right? Just read the last part of it and thank you very much. No, you're supposed to read it completely and see that how Honorable Court, Supreme Court came to a conclusion, how they decided the ratio, and finally the operative part of it. Now, paragraph number 12 is really very important, where Supreme Court is saying that we are more concerned with section 173, as we have found that investigating officers, while submitting the charge sheet / police report, do not comply with the requirement of the said provision. Though it is true that form of the report to be submitted under 173(2) has to be prescribed by the state government, or each state government has its own police manual to be followed by the police officer while discharging their duty. The mandatory requirements required to be complied with by such officer in police report / charge sheet are laid under 172, more specifically 173(2), which is section 173 subsection 2 of CrPC, because it is where the charge sheet is filed. 173(8) is generally the supplementary charge sheet. 173 6, you can say, when in the interest of natural justice or public protection, or there is any evidence which police wanted to make sure that he or she should be safe, they are not revealing the name and so on and so forth. Now please take a note that point number 14 is relatively very important. Now, when the police report is filed before a magistrate, and in this police report, it could only be two ways. Either the offense is made out or the offense is not made out. Ladies and gentlemen, when you are using a word offense, then I always say that the Lalita Kumari State versus UP, Adesh Kumar versus State of Bihar, and there are catena of judgments which are in this regard, needs to study and needs to interplay. So, example, in a matrimonial case, in a dowry dispute, in a family dispute, the preliminary investigation is must. And that preliminary investigation is time bound. We need to put this in the general diary also. Of course, the general diary comes under 172 CrPC, and I understand that accused having no right to have a copy of the general diary, he need to request to the relevant court to have a copy of the general diary in place, provided there is something which he can substantiate and so on and so forth. Now, here in paragraph number 14, which is very important, and what Supreme Court is saying, that when such police report concludes that an offense appears to have been committed by a particular person or persons, the magistrate has three opinions. Number one, he may accept the report and take the cognizance of the offense and issue process, which means then he would be framing the charges, and then the trial will start, the witness, evaluation, cross-examination, so on and so forth. Point number two, he may direct further investigation under subsection 3 of 156(3) and require the police to make a further report. Please take a note that he may further investigation on a relevant point. It is not a de novo investigation. Because if we want a de novo investigation, then there are certain guidelines which are framed by Honorable Supreme Court of India for the higher courts like High Court of India, High Court of the States under 226 and 227, read with 482. Please don't expect me to read these guidelines, because for de novo investigation, de novo means whatever happened is now zero. Now we again start, which is void ab initio, means whatever effort we made is zero. Now let's start from the scratch. Here, the appropriate guidelines are framed, so please refer the judgments. Point number 3, he may disagree with the police report and discharge the accused on the drop of the proceedings. Or drop the proceeding. Please take a note that discharge is very important. We soon would be deliberating on the discharge, which is 239, date with 251, how discharge happened, what are the various formalities, what are the various legal issues in discharge, so on and so forth. But having said that, discharge is one of the finest point we are having in criminal jurisprudence. I request you to please visit paragraph number 15, because here Supreme Court linked the explanations with two judgments. Number one is 1983 SCC 152 and Dinesh Dalmia versus CBI, Central Bureau of Investigation. Now, ladies and gentlemen, if I reach to the page number 11 of the judgment, please note that here the Supreme Court issued in paragraph number 17 what Honorable Court is saying. Ergo English means therefore. Ergo, having regard to the provisions contained in the section 173, it is hereby directed that report of the police officer on completion of investigation shall contain the following. Please note the word shall contain the following. Now, what Supreme Court is saying, I'll go point by point. A report in the form prescribed by the state government, the name of the parties, the nature of the information, the name of the person who appears to be acquainted with the circumstances of the case, whether any offense appears to have been committed and if so by whom, whether the accused has been arrested, whether he has been released on his bail bond and if so whether with or without sureties, whether he has been forwarded in custody under 170, which CrPC 170, whether the report of the medical examination of the woman has been attached where investigation related to an offense under 376, 76A, AB, B, C, D, DA, DB, or 376E of the Indian Penal Code. If upon the completion of investigation there is no sufficient evidence or reasonable ground of suspicion to justify the forwarding of the accused to a magistrate, the police officer in charge shall clearly state in the report of the compliance of the 169. 169 is, in a plain language, is said as a closure report. When the report in respect of the case for which section 170 applies, which means we are going ahead to present before the magistrate, the police officer shall forward to the magistrate along with the report all documents. When I use the word all documents, I mean to say 173(5). I repeat, section 173, subsection 5. All documents or the relevant extract thereof on which the prosecution proposes to rely other than those who are already sent to magistrate during investigation, and the statement recorded under 161 of the person whom the prosecution proposes to examine as a witness. In the case of further investigation, the police officer in charge shall forward to the magistrate a further report or reports having such evidence in the form prescribed, and shall also. Please note, Honorable Supreme Court is mentioning shall again and again. Comply with the detailed mention in the above subpara 1 and 3. Ladies and gentlemen, these guidelines which Honorable Supreme Court of India framed, white dated 12th March 2024. These guidelines pertains to the how police officer should submit a charge sheet when it comes to a criminal jurisprudence. Please take a note. Paragraph number 18. It is further directed that officer in charge of the police stations in every state shall strictly comply with the aforesaid direction, and the non-compliance thereof shall be strictly viewed by the concerned courts in which police reports are submitted. Paragraph number 19. The copy of this order shall send to all chief secretaries of the states / union territories, and also to the registrar generals of the High Court for perusal and compliance. The appeal stand disposed accordingly. That appeal is a separate thing. Ladies and gentlemen, this judgment is again one of the landmark judgment, because here also the guidelines which are framed by Supreme Court that how charge sheet to be put into the picture. More importantly, Honorable Court in paragraph number 18 clearly said that it is further directed that officer in charge of the police station in every state shall strictly comply with the aforesaid directions, and the non-compliance thereof shall be strictly viewed by the concerned court in which the police reports are submitted. This is what I wish to say. I further conclude that charge sheet is one of the most important documents police authorities are putting before the court of law. Because if police is not filing a closure report, and if they are going ahead with the charge sheet, it means that they are having something which can act as an evidence. But more importantly, I wish to have one respectful submission before Honorable Supreme Court of India, and that respectful submission is that we all know CrPC 207, the copies of the charge sheet, FIR, and all other relevant documents to be provided to the accused, and the accused defense is completely based on that. Now, my respectful submission to Honorable Supreme Court is that when we are having these directive guidelines by you, dated 12th March 2024, in that sense, when the CrPC 207 compliance to happen, it practically means that this compliance of 207 to happen on these directive guidelines, which means the charge sheet should be in this order or should cover the following. It means if it covers the following, then the CrPC 207 to also cover the following, because the accused defense in the criminal jurisprudence depends upon the documents on which the prosecution is relying. Witnesses, evidences, and FIR copy, charge sheet copy, the charges which are framed, and so on and so forth. My respectful submission here is that CrPC 207 is nothing but, I would say, we can divide this into two parts. Number one, the documents which going in the favor of state. Number two, documents which are not going in the favor of the state. Now, based on these directive guidelines which are given by Supreme Court, and Supreme Court clearly saying that all officers in charge of the police station of every state to comply with this. And also, Supreme Court is clearly saying that in the absence of the compliance, the relevant court of that state to take a strict view shall strictly viewed by the concerned court in which the police report are submitted. So I hope that 207, the copies of the 207, now to be linked or to be provided, although there are enough judgments of 207, and soon I would be covering 207 in detail, and of course, like I said, with the judgment of Honorable Supreme Court of India. Thank you very much, ladies and gentlemen. This is Rahul Magan. You have my number 9899242978. Thank you to Supreme Court.